So, we'll discuss regarding Section 5 of the Hindu Succession Act 1956. And this very provision under Section 5, as this act does not apply to succession of property regulated by Indian Succession Act 1925, with relation to Section 21 of the Special Marriage Act 1954, as it creates a special relationship. So, these children born out of those marriages are not governed under Hindu Succession Act 1956. And now we'll go to Section 6 of the Act, which relates to devolution of undivided share. And regarding that, the very rule is co-partitionary property, and to determine the very share of a heir, the rule of survivorship and the rule of succession is applied. And subsequently, one important amendment was made to the Act in 2005. So, Section 6 to 17 of the present Act deals with intest succession, and exclusively Section 6 provides devolution of undivided share in Mitakhara co-partitionary property, and that means an ancestral property. The two modes of devolution provided in this section are the rule of survivorship and the rule of succession. The rule of survivorship applied with respect to co-partitionary property, whereas the rule of succession applied to property held as separate or self-acquired property. The first part of the provision of Section 6 shall come into operation when there is no female heir, as mentioned in the list of Class 1 heirs of the schedule. And regarding the second part of this Section 6, it confers new rights upon the specified female heirs mentioned in Class 1 heir of the mentioned schedule, and superimposes upon the entire structure of Mitakhar law of survivorship a rule whereby female heirs would replace such heirs who have not found place in Class 1 of this schedule. So, we found difficulties in interpretation of the first part in combination with these provisions of second part of this section. So, to remove the differences in application of these two provisions, as we have discussed in part 1 and part 2 provisions of Section 6, an amendment was brought into the Act, which came into effect from 9/9/2005, and now we'll discuss certain leading cases relating to devolution of undivided share on the basis of co-partitionary property on the application of rule of survivorship and rule of succession. So, the first leading case, Tripur Sundari versus Srinivas Pillai in 1972, the Madras High Court held that this section does not apply to separate property obtained at partition of the coparcenary on the death of an intestate person is intestate in the coparcenary property devolved to the male heirs and not to others. So, in another leading case, Anand Naik versus Haribandhu Naik in 1967, the Odisha High Court expressed that rule of national partition even before the Supreme Court decision given in 1978 on his own heirs, that is, his widow and daughter, and another leading case, that is G.B. Krishna Rao versus Andhra Pradesh State in 1987, the Andhra Pradesh High Court held that in the death of an instate person, all heirs, including the male and female, would be entitled to equal share. And in the next leading case, that is Gurupad Khandapa versus Hirabai in 1978, Supreme Court held that the controversial and conflicting decisions of various high courts regarding interpretation of Section 6 was put into rest and a specific share would be allotted to the widow in the interest of her deceased husband. And in the last leading case, that is State of Maharashtra versus Narayan Rao in 1985, Supreme Court held that a female member who inherits an interest in the joint family property would be entitled to her share, expressing her willingness to go out of the family if she filed a suit of petition. She does not cease to be a member of the joint family on the death of the male member of the family. So, the very provision of Section 6 dealing with devolution of undivided share regarding the property of the coparcenary property, which is the ancestral property, as the very rules which are governing the very devolution, that is rule of survivorship and rule of succession, and as the very confusion or conflicting differences arised due to the conflicting decisions of several high courts, an amendment was enacted in 2005 and it came into effect in September 9 of 2005, and to remove all those controversial and conflicting decisions of various high courts. Finally, in the leading case Gurupad Khandapa versus Hirabai in 1978, Supreme Court put into rest all those controversy and conflicting opinions and decisions held by several high courts, and a specific share would be allotted to the widow in the very interest of her deceased husband. So, this is all about Section 6 of Hindu Succession Act 1956 regarding devolution of the very property of the deceased person on regarding the very coparcenary or ancestral property as provided under the very provision of section 6 and also regarding the very amendment of 2005 and the various confusing decisions of several high courts and finally the decision of the Supreme Court to put into rest all those controversial decisions we already have discussed in this video, and in our next video we'll definitely discuss regarding the very provisions of section 7 which deals with also devolution of interest in the property of Tarwad or Tabjai or Ilam or etc. as it is prevailing in South India.